Okay, let's get started. Welcome, everyone. I'm John Chalmers. I'm the Dean of Admissions. Thank you for joining us. I see some of us from you guys from the West Coast, so thank you for getting up so early this morning to join us for this exciting mock class. We're going to get started quickly. I'd like to introduce, before we start the actual mock class, the Dean of our law school, Dean Lisa Freudenheim. Would just like to say a couple of welcome words to you. Thank you.
Welcome, everyone, and congratulations. This is such a wonderful opportunity for you to have a taste of New England, and for us to just start to bring you into our culture and our school. You're going to have the good fortune of getting to hear one of my favorite professors, Professor Vic Hansen, who is going to do a mock class today on criminal practice and procedure. When I think about our law school and what I would say is the number one reason why students really flock to New England, it's our incredible professors and our sense of community and the teaching that goes on. So in the classroom, it's going to be a little different, but this gives you a taste of what we offer. And so we're delighted that you get a chance to experience this today. I also really want to congratulate you and honor all of you. This is a big deal. You're accepted into law school, and you should take a moment and truly reflect on how major this accomplishment is, and how hard you worked to get here. You are a pretty amazing group of individuals, and hopefully future members of our community here. We've got people joining us on this call alone from more than 30 different states, and some of you coming straight from undergrad, some of you having worked for a while. You know, what I've noticed over the years is that students always bring their unique experience and personality to our community, and it enriches us in so many ways. So we're delighted to have you here, and I'm going to turn it over to, I think, Professor Hansen at this point, and have a wonderful time and enjoy this opportunity.
All right. Well, good morning, everybody, and welcome to New England Law. Just a little bit about my background. I've been here at New England Law Boston now for, I think I'm on my 16th year of teaching. Prior to joining the faculty here at New England Law, I was an Army JAG officer, military lawyer for 20 years in the Army JAG Corps. And in that capacity, I had the opportunity to do a lot of very interesting work. But among the things I did primarily, excuse me, it was I was a prosecutor in military trials, and later in my career, I was a defense attorney in military trials. So I have a lot of criminal law experience. I actually also taught for a period of time at the U.S. Army JAG School. And so kind of leveraging all of that experience that I had as a practitioner and as a teacher in the Army, when I retired, I joined the faculty here at New England Law Boston, and have had really a fabulous experience here teaching and working with students. I teach a number of required courses in the curriculum, including criminal law, which is a first-year required course, criminal procedure, which is a second-year required course, evidence, which is a second-year required course, and then I also teach some other advanced classes in prosecutorial ethics, in national security law, occasionally in international criminal law, and I also coach our mock trial team. We just finished our regional competition this past weekend, but that gave me an opportunity gives me an opportunity every year to work with a small group of students who are on our team to represent the school in our competitions. So and again, I'm looking forward to having you here, and it looks like we do have the slides up. So, Anne, I appreciate that. We'll start with the first one, which is the objectives. And I will tell you, that's kind of how I run my classes, and most faculty also run their classes, where they will identify what the learning objectives are for the various material at the very beginning of the class. And I do that for every class. And the goal there is so that when you, sit down and kind of assess what you're learning and what you're understanding, you have a way to kind of check your understanding and say, well, did I achieve the objectives that were intended with this material? So today what I'm going to do is give you a kind of a condensed version of one of the classes that I teach regarding Fourth Amendment protections. Fourth Amendment is the amendment that deals with searches and seizures, And it's part of a criminal procedure class, again, a second-year required course, which really focuses on constitutional rights of all of us, but as they apply in the criminal context. So, Anne, go ahead and highlight the next slide if you don't mind. So this is the language of the Fourth Amendment. And it may surprise you a little bit to know that, one of the things in law school that you learn to do in kind of thinking like a lawyer, if you will, you spend a lot of time, with language, and you spend a lot of time, carefully dissecting and understanding terms. We spend in the criminal procedure class that I teach, we probably spend about 2/3 of the entire semester just dealing with the Fourth Amendment. This seemingly very short paragraph has a lot to it. So what we're going to talk about today is specifically this notion of searches. One of the things that the Fourth Amendment clearly deals with by its language is it prohibits the government, the police and government officials from engaging in what are deemed to be unreasonable searches. But before we can frankly know what's unreasonable, we first have to determine what it means to search something. Now, my guess is that all of you, probably in your head when I ask you, well, what is a search? Maybe different thoughts come to mind. And I know there's a bunch of you out there, so I'm curious, is anybody, using the chat feature or whatever, what would you say when you hear the term search? What kind of thoughts come to mind in trying to determine what a search is? Anybody have any thoughts? Okay, can I look around a little bit, Amy says. That might be a search. Anybody else have thoughts about just you put a couple, looking through something not publicly displayed? Okay, that's a very technical term, but I think perhaps appropriate. I'll look, see for a couple more come running through personal items, patting somebody down. Okay, physically moving and touching items. So we've got a lot of different, thoughts or ideas that come to mind when we consider the term search. What we're going to discover here today, that in the context of the Fourth Amendment, search has a very precise meaning or a precise term. And we learn this, and this is typically how you learn a lot of things in law school. You learn them by reading cases, by reading court cases. And in this class in particular, what we focus on is Supreme Court cases, because it's the Supreme Court's responsibility to provide meaning or constitutional definition as to the provisions of the Constitution and what they mean. So Anne, if you could go ahead and highlight the next slide, the one that says Katz facts. Okay, so this case happened several years ago, back in the 1960s, and it involved the police listening to a conversation. Now, I put this picture up here because it actually involves using a phone booth. And of course, that's a bit dated. My guess is that some of you may not even be sure what a phone booth is. I'm certainly aging myself when I say, yeah, I know what a phone booth is. I used to use them all the time. Of course, in our modern era of cell phones, we hardly see phone booths anymore. But back in the 50s and 60s and 70s, and frankly, probably up into the mid 80s before cell phones became so ubiquitous, that's how people made phone calls. If they weren't by their home landline, they'd be walking down the street, they would see a phone booth, they'd put some money in the phone booth and make a call. And in this case, what Mr. Katz did is he was using a phone booth to make calls, but actually what he was conducting apparently was some illegal gambling operations. And so the person he was calling on the other end of the line was somebody he was trying to have a gambling, engage in some gambling, illegal gambling with. Well, the police suspected that might be going on, and they wanted to kind of catch him in the act, if you will. So what they did, they didn't do a wiretap where they listened into the phone conversation between the two of them, because they probably didn't have the authority to do that. Maybe they didn't even have the technology to do that. So instead what they did is they put a microphone on the outside of the phone booth, kind of this little cup microphone. And they used that to basically eavesdrop on his half of the conversation. and listen to what he was saying to the other person. And then they wanted to use that evidence at his trial to prove that he was in fact engaging in gambling operations. So the question that the court had to deal with is, was the use of this microphone attached to the outside of the phone booth, was it a search under the definition of the Fourth Amendment? Because if it's a search, then the Fourth Amendment has several requirements. There has to be a warrant. A judge has to approve the warrant, and they have to establish probable cause before they can engage in the search. On the other hand, if whatever the FBI did does not constitute a search, then they don't have to comply with the other requirements of the Fourth Amendment. So that was the question here. Is it a search? Now, as you think about these facts, and as you consider what the FBI did, what might be relevant if you were to sit on the court, if you were asked to be a Supreme Court justice for a day and these facts came before you, what might you consider to be a relevant facts or considerations in determining whether what the police did here was or was not a search? Go ahead and again respond in the chat feature. I know I won't be able to get to all of you, but let's see what a couple of you or a few of you have to say in terms of facts that you might be focused on to determine whether what the FBI agents did here was a search. Okay, somebody says, well, it could be a breach if they have expectation of privacy, but it is a public phone. Somebody's asking, well, was the door open or closed? Maybe that's relevant to see whether they thought the conversations were private. The device could only hear Mr. Katz's end of the conversation, so they couldn't hear the whole conversation, just his half. Okay, another fact that somebody thought would be relevant was whether or not Mr. Katz knew that they were recording his conversation. And I'm guessing they didn't know that, right? Because he didn't know that, because if he'd have suspected the FBI was listening in on his calls, he probably wasn't going to engage in this conversation. Well, and again, some are questioning about probable cause. Again, if it's not a search, we don't need probable cause. That's the whole point. If it's not a search, the requirements of the Fourth Amendment don't apply. Well, so here's what the court did. Now, all of you are listing some pretty important facts and in terms of what the Fourth Amendment is intended to protect. And that's really what was at issue in this case. Prior to the Katz case, there had been a long line of cases where the court, to determine whether something was or was not a search, would often say, well, was there a trespass? Did the police trespass on property? And they kind of used a property analysis in determining whether something was or was not a search. Well, in the Katz case, the court changed the test, if you will. They recognized that just doing a property analysis may not get to the heart of the issue. And instead they said, you know, the Fourth Amendment doesn't just protect property, it protects privacy. That's the real core of the Fourth Amendment. And so the court further determines that if whatever the police do violates somebody's personal belief, subjective expectation of privacy, and that other people, the rest of society, would deem it to be a reasonable expectation to have, then whatever the police did is a search. So putting it in the context of the Katz case, the court says, well, wait a minute. When people use phones in a phone booth that has doors that can be closed, even if it's quasi in a public space, for a certain period of time, it's kind of a private area. You know, people go into the phone booth, they close the door, they don't expect the public to generally be listening. And so based upon that conduct, the court says, well, people, you know, they have an expectation that the conversation is going to be private. And it's something that we as society would deem to be reasonable. So based upon those conclusions, as it applies to these facts, the court announced a new test. And Anne, can you go ahead and go to the next slide? So the test that the court basically articulates after the Katz case to answer the question of whether something is or is not a search is if, in the second bullet here, a Fourth Amendment search occurs if a person searched had a subjective, a personal expectation of privacy, and if the expectation is one that society is prepared to accept as reasonable. So kind of the shorthand that we typically use for this test now is what's referred to as a reasonable expectation of privacy. Do they have a reasonable expectation of privacy? So now that doesn't answer every question, but at least it helps orient, future courts and future litigants and the police and others to know when their conduct may or may not constitute a search. Okay, so that's the Katz case, and that's the law of the land as it exists today. Even though the case is from the mid-1960s, even today, that's the question we ask to determine whether the police engaged in a search. Did the person have a reasonable expectation of privacy in the area searched? But like everything else that in the law, nothing is quite as simple as it might initially seem, because what ends up happening then, you create this test, well, then a new set of circumstances might come along. And then you have to step back and say, well, how are we going to apply this test in some new circumstance? So let's go ahead and go to the next case, the Smith case. Now, Smith is kind of an interesting case. It happened after Katz. It also involved phone calls, but it was slightly different here. What we had in Smith is we had a defendant who had actually robbed the victim some days earlier. And after robbing the victim, the defendant continued to harass her by calling her on the phone at all hours of the night, by driving by her apartment and continuing to harass her even after he robbed her. So the police wanted to find out, well, who this guy was. She didn't at least have caller ID. So when he called her home, again, this is from the 1960s, when he called her home, the number didn't come up on her phone. So she didn't, she couldn't prove it was him, but she suspected it might be him. So she contacted the police and told them what was going on. And so what the police did is they actually went to the phone company and they said to the phone company, hey, here's what we'd like you to do. We would like you to put what's called a pen register, P-E-N, a pen register on the victim's phone line. And that pen register, or actually, no, I'm sorry, not on the victim's phone line, but on the defendant's phone line. And that pen register that the phone company puts on the phone line will tell the phone company the phone numbers that the customer has called. It won't listen to the conversation, but it will just be able to determine what calls were made from that phone into what numbers. So the phone company did that. They did that at the request of the police, and surprise, surprise, when they put that pen register on the defendant's phone, it showed that he was actually trying to call, or he'd made numerous calls to the victim. And that, coupled with other information that the police gathered, allowed them to get a warrant to search and ultimately arrest the defendant. Okay, so the issue in this case is whether or not the use of this pen register by the phone company at the request of the police, whether that was a search, whether, in applying our reasonable expectation of privacy, the question we would ask is, or the question the court asks is, does the defendant have a reasonable expectation of privacy in the phone numbers he dialed from his phone? Okay, so again, I'm going to turn it over to the group and say, what would be important in your analysis of answering that question to determine whether we think he would or would not have a reasonable expectation of privacy? What facts might be relevant in order for you to answer that question? Okay, so one says, in the contract with the phone company, did they have rules on privacy? Excellent question. Was he on notice that the phone company might be monitoring his phone numbers? let's see, did the phone company have expectations that that this would be private? Okay, let me see if I got some others up here. Those are some good questions. You'd say, well, numbers are public and companies regularly record those numbers. So maybe we kind of have an expectation that the phone company knows what phone numbers we call. So those are all good thoughts, and those are certainly factors. Were the numbers recorded unrelated to the victim? Is it a public record? So those are all excellent questions. And that's kind of some of the things that the court looked to decide whether or determine whether or not he has a reasonable expectation of privacy in the phone numbers that he calls. And here's what the court said. They said, well, look, every month the defendant got a phone bill. And in that phone bill, it listed all of the numbers he called, all the phone calls he made, because they had to show him that to show what his charges were for the month. So he was on notice. Maybe he didn't pay close attention to his phone bill. I mean, in this day and age, I get my phone bill from Verizon and it's so thick, I have no time to look through it. I just pay the bill and move on. But if I took the time to look through my phone bill, I would probably realize, oh, wow, Verizon's collected a lot of information about my phone usage. So the court says, well, maybe whether he actually knew it, he was kind of on notice that the phone company would do that or had the capacity to do that. The court also pointed out that, and we don't get these anymore, again, this is kind of a dated case, but back in the day, the phone company every year would also give all their customers a phone book that would list all the numbers, in the area of people, their addresses, their phone numbers, so somewhat that information is public. But also in the phone book itself, there was this language that would basically alert customers to say that the phone company could periodically monitor the phone numbers you dial. So the court concluded based upon that information, and importantly, because they weren't listening to the conversation, just the numbers dialed, the court concluded that he did not have a reasonable expectation of privacy in those phone calls, those phone numbers dialed. And what kind of emerged from this case is also this notion of, what we knowingly disclose to other people, like the phone numbers we dial, we no longer have an expectation of privacy in that information. Once that kind of gets out to third parties, we lose any expectation of privacy in that information. So let's go to the next slide, Anne. And now we have, and this is something we always have to do, we start off with our basic rule, reasonable expectations of privacy, but then we have to add some modifications to it when a new case comes along. And so the modification that we add here is, well, okay, there's this reasonable expectation of privacy test in the first bullet, but look at the second bullet, the italicized language. When people voluntarily disclose information to third parties, like the numbers that they dial, they no longer have a reasonable expectation of privacy in that information. And they kind of assume the risk. They assume the risk that the public is now, or somebody, the police or somebody else, can get access to that information. Now, I think it's useful to question whether that's how we actually think in our everyday lives. Do we always think, oh, anytime I say something or disclose information, there's always the risk that the police are going to have access to it? And I'm not so sure that that's how we behave in our everyday lives. But the court said, from the Smith case, you lose your expectation of privacy in that situation. Okay. So now let's go to the next case, which deals, again, it's a similar scenario, but it's a little different context. And this is the Ciraolo case. Now, I know, well, at least here in Massachusetts now, I know some of you are from all over the country, but this case is a bit dated because marijuana in Massachusetts is now legal. But in some jurisdictions still, and back when Ciraolo was decided, it was not legal anywhere. We had a defendant who was engaging in growing marijuana. Now, he wasn't just growing it out in the open. For example, if he had just had marijuana plants in his front yard and had a growing operation there, and the police or the public could see his growing operations from the front yard, it would be really hard to say that he had a reasonable expectation of privacy in growing the marijuana, because clearly anybody in the public could have seen that. But Ciraolo was a little more careful than that. So what he did is he grew his marijuana in the backyard. But not only did he grow it in the backyard, he put a tall fence around the growing operations so that anybody walking by, or even the neighbors or somebody in the public, if they walked by and looked into his yard, they couldn't see it. He had shielded from the public eye. So it seems like in doing all of that, you know, at least subjectively, he had an expectation of privacy in keeping this information private, the fact that he was growing marijuana. Well, so the police suspected he might be growing marijuana. It's not clear how they suspected it. But what they did, rather than trying to climb the fence, because if they had climbed the fence, that probably would have been a Fourth Amendment violation. So instead, what they did is they got an airplane. And they put a couple of police officers in the airplane and gave them some binoculars and had them fly over the yard and look in the back, using the binoculars to see if they could determine if what he was growing in the backyard was in fact marijuana. And so that's what the police did. They flew over the backyard, and they were at about an altitude of about 1,000 feet. And apparently, I mean, I don't know how they could see it from 1,000 feet, but apparently these officers, with the use of binoculars, were able to look down in the backyard and determine that what he was growing was marijuana. So based upon that information, and they did all this without a warrant, they didn't get judicial approval. So based upon this information, they got a warrant. But the issue for the court, again, was, well, if what they did in flying over the backyard, if that wasn't a search, then there's no Fourth Amendment violation. On the other hand, if it was a search, then we have an illegal search, and that would taint anything that followed. So any warrant that came from that would be invalid. All right, so here we go, back to the group. What facts do you think would be important for the court to look at in deciding whether or not the defendant in this case had a reasonable expectation of privacy? Okay, so one really good question is, do you own your own airspace? Okay, and if you do, to what height? Air is public domain. Okay, one other concern is they're using binoculars. That's not just using it with the naked eye. Okay, can lay citizens view the backyard by flying over the house? These are all really, really excellent questions. You guys could already be on the Supreme Court today. You're asking all the right questions. You're asking the very questions that the Supreme Court asked when they looked at this case. And here's a couple of things they noted. Okay, first of all, yeah, the police were using binoculars, but it wasn't some specialized, you know, kind of binocular. It wasn't like infrared binoculars or anything else. It's probably the kind you could go down and get it at Walmart or Bass Pro. So anybody in the public could have had these binoculars. The court said that was important. But also notice, one of the critical things for the court was the plane that the police were using was flying at 1,000 feet. And what's significant about 1,000 feet? Well, that is what's determined to be navigable airspace, meaning that's a space that anybody in the public could fly over at that altitude. So if a plane was flying overhead, somebody in the general public was flying at 1,000 feet, that's in the public airspace. It's not in the defendant's private area. So based upon those critical factors, the court said it's not a search. He kind of knowingly disclosed this information to anybody in the flying public who could have seen this from 1,000 feet. Now, Alexa, you raise a really interesting question, because this case happened well before Google Earth and before we now have even more ubiquitous satellite images that we all have access to. So now, you know, given how precise satellite imagery can be and how easily it can be for the general public to have access to, it kind of raises the question, does anybody have a reasonable expectation of privacy in the things that they do in their backyard. If a satellite can see it, and if Google Earth can see it and capture it on an image, then how can anybody say they have a reasonable expectation of privacy in that information? Good question. I don't know the answer to that, but that's certainly a good way to take these concepts and bring them up to our modern circumstances and situation. So again, we've got to kind of further refine our tests. So Anne, can you go to the next slide, please? So we've got some further refinement here. Remember, we started out with this reasonable expectation of privacy. That was our first test. And then it says we assume the risk when we disclose information to non-law enforcement third parties, and the third party shares that information with the government. And also this further refinement from Ciraolo, what we hold out to the public may not be protected if there's no government trespass involved, and if there's no exposure beyond what the public could generally see. All right. So with that, now I'm going to give you a new case. So Anne, go to the next slide, please. Now this case, Carpenter versus United States, was recently decided by the Supreme Court. But I don't want anybody Googling it. I want us just to kind of come into it with a fresh set of eyes. So Carpenter kind of brings all of these concepts together, but it does so in the context of a much more modern technology. In this case, we're talking about cell phones. So what happened in Carpenter is we had a defendant, excuse me, who was suspected of actually engaging in a number of burglaries of, lo and behold, cell phone and electronic stores, Radio Shacks, T-Mobile stores in an area in near Detroit. Now, how the police were able to piece together that he was involved in these burglaries is they got information from his cell phone carrier. The information they got is called cell site location data. Some of you may be more familiar with this than I am technologically. But just so you should know, I've got my little smartphone right here. We all have our smartphones, right? So in order for these smartphones to work, they have to link up to a cell phone tower. And it's, connecting to those cell phone towers allows the connection to take place, and then the number goes through, et cetera, et cetera. Well, it turns out phone companies are constantly monitoring this cell phone information. So even if I'm not currently using my cell phone, so long as it's on, which it is, periodically this cell phone, frankly, unbeknownst to me, is reaching out to cell phone towers. And it's saying, here I am, here I am, here I am. And the cell phone companies use this to determine what their signals are, to determine where they should be placing cell phone towers to get good coverage, et cetera, et cetera. But for me personally, what that means now, and this is what happened in Carpenter, is the police, or the cell phone company rather, has really specific, detailed information about the location of my cell phone. And they maintain this information for 5 years. So in essence, the phone company can go back to the past 5 years, pull up my phone number, and be able to tell with a very high degree of accuracy, probably within 100 meters or so, everywhere my cell phone, and by extension, because we're never very far from our cell phones, by extension, where I have physically been over the past 5 years. Now that's a lot of information. It's a lot of very specific, detailed information. And what happened in this case is the police, when they wanted to find out if Carpenter was in fact located in areas where these burglaries took place, they simply reached out to the phone companies and said, give us your cell phone data on this phone number. And based upon that information, they were able to determine that in fact, at the very time these burglaries were taking place, Mr. Carpenter was within a very, close location to where those cell phone towers were, and where the robberies or the burglaries took place. So the issue before the court here was this a search? Do we have do we have a reasonable expectation of privacy in this information? Or is this, using the third-party doctrine and what we knowingly disclose to the third parties, is this like the Smith case and the Ciraolo case where we don't have an expectation of privacy? What do you think, folks? How would you rule on this one? So we have some people saying, well, if your cell location is turned on, maybe you lose the expectation of privacy. What does the cell phone contract say? My response to that one, Samuel, is who knows what the cell phone contract says? Does anybody really read those contracts? I'm a lawyer. I don't read those contracts. Is there a disclaimer in the phone company that says what they're going to use them for? Is it common knowledge that phone companies have this detailed information? All really good, relevant questions. And if we apply the doctrines that we've just been talking about, we might say, hey, this is, you maybe don't have a reasonable expectation of privacy in this information. Well, so I'm going to tell you what the court did here. Very surprising. The court said this was a search. Why? Why, if the phone numbers called in Smith are not likely to, or are not a search, but the cell phone location data in Carpenter is a search? Can anybody figure out what's critically different about the information that would make one a search when the other is not? How are these different in a significant factual way? Location data involves us. Numbers are used for billing. More personal information. Is it because location data is something you have reasonable expectation of privacy in? Okay, all good points. And here's what the court in essence says. They said that, look, cell phones are different. The kind of information that they can provide is much more detailed. It's much more personal. It's much more specific. And I think also quite important for the court was cell phone companies maintain this for a long time, 5 years. And all of that, the court suggests, is so invasive and potentially so intrusive on somebody's privacy, coupled with the fact, and I'm not going to do a poll here, but I'm guessing that each of you on this call right now, you're probably within arm's reach of your cell phone right now. Most of you are, a vast majority of you. And I think the court said, the way that cell phones are used in today's modern society, the ubiquitous nature of cell phones, that everybody has one, everybody uses them, everybody is so connected to them. And the information that's gathered and stored and maintained is so deep and intrusive that it actually constituted a search in Carpenter. And that was kind of surprising to a lot of people, because if you had looked at the prior cases, many of us, including myself, would have assumed that the court would have gone the other way, but they didn't. They saw cell phones as something different. All right, well, so that's a good place to stop, but this kind of gives you a bit of an indication of how we would do a class. Now, if this was actually a class, I would probably have more questions of you. I might have a student provide the facts of the case and probe students a little more deeply in terms of what the court's analysis on a particular point of law was. But of course, they would have read the cases in advance. At least I hope they would have. So they're prepared for that discussion. But this is not unlike the kinds of things you would talk about in a criminal procedure class. And then what I would likely do is present you a new set of facts and a new set of circumstances and say, okay, how would you, what arguments would you make that this does or does not, fit within the Carpenter line of cases or the Smith line of cases, and expect you to develop arguments for both sides of the issue. What arguments the prosecution might say that this is not a search, what arguments the defense might say it is a search, and get you to kind of do a more in-depth legal analysis of these issues. But that's what you'll do a lot of in your law school classes. It's a very, hopefully, a very back and forth conversation that we have with students, and kind of push their knowledge and push their understanding and force them to think about things in perhaps a new and exciting way. So that concludes my presentation. I said I'd be happy to hang around for a few minutes for folks if they have questions, but for at this point, I want to turn it back over to our hosts, I guess, Anne or others who might want to moderate if there's questions or what the next step in the process is.
Thank you, everybody, for coming. Professor Hansen, that was amazing. I'm going back to Professor Hansen now because Professor Hansen was my professor for evidence, and he has always ranked at the very, very top, if not my very favorite. And I always like to leave room in case there's another professor I also like, and I don't want anyone to know who's number one. I don't even know who's number one. But thank you so much. Thank you for coming. And I'm going to turn it over to the Dean of Admissions, John Chalmers.
Thank you. Thank you, Professor Hansen. That was, as always, great. Thank you, Ann. Thank you all for coming. If anybody has any last-minute questions, we're happy to kind of stick around a little bit and answer them. But if not, that's the end of the mock class, and we'll see you at our next event. We have plenty of things coming up, so looking forward to seeing you all there.